Hi, everyone. I'm attorney Donna DiMaggio-Berger, and this is Take It to the Board, where we speak condo and HOA. Most people don't read the fine print until it's too late. But in the world of community associations, the fine print in a contract can be the difference between a smooth partnership and a costly disaster. On this episode of Take It to the Board, I'm joined by my law partner, Rob Caves, a seasoned transactional attorney located in Fort Myers, Florida, who has spent decades drafting, negotiating, and, when necessary, untangling problematic contracts for his community association clients. Today, we're going to break down the most common pitfalls, the must-have provisions in your contracts, and negotiation strategies that every board member and manager should know about before signing on the dotted line. So, Rob, welcome to Take It to the Board.
Great. Thanks, Donna. Thank you for having me.
So happy to have you. We have not talked about this topic in 4 seasons, Rob. Can you believe it?
Wow. I figured this was, your third or fourth episode on contracts.
No, it's the first. And so we're really going to spend a little time breaking things down. Why don't we start with some of the verbiage? We hear a lot of terms that are thrown about, and one that gets tossed about a lot with clients and managers and vendors is proposals versus agreements versus contracts. Is there any distinct difference, Rob, between a proposal that a vendor gives you versus a contract or agreement?
Oftentimes, yes. A lot of times vendors will have a proposal, which is really more of a marketing document. Nothing wrong with that, but it oftentimes doesn't contain all of the necessary material terms to be an enforceable agreement. So, you may get proposals from a number of different vendors for, whatever service the association is out there looking to acquire. But ultimately, those proposals or those estimates or whatever those marketing documents are called will have to be reduced to a contract, to an agreement that both parties sign, the document that's going to have all the material terms and conditions in it. Now, sometimes those proposals get incorporated as an exhibit, for example, to the contract, but the proposal itself oftentimes isn't a binding agreement. It's really more of a, it may contain business terms and it may contain scope of what's being proposed, but it's not going to be the document that is ultimately signed and enforceable, between the parties.
It sets out the full understanding of what both sides are agreeing to. I think it's an important distinction. I've had clients say, we've signed the proposal. Of course, we're going to talk about that today, about clients who call us after they sign the contract.
Exactly. Yes. One of my favorites.
Not the best idea. Let's talk about the parties. So, I would think the starting point, Rob, is due diligence, that the vendor or the party that the association that your client is looking to do business with, that they've done some due diligence on that party, and that the name in the contract, believe it or not, sometimes does not reveal an active corporation, an active business entity. Can you talk a little bit about due diligence in terms of who you're doing business with?
Sure. So, we assume you're kind of to the point where you've interviewed a variety of different vendors, you've picked one, you've hammered out or started to hammer out the business terms, and now you've got something in the form of an agreement or contract to look at. And it's got names at the top, right? It's got the condominium's name, we'll come back to that, and it's got the vendor's name. And you have to check that, or you need to have your attorney check that with the Florida Secretary of State's records. The Florida Secretary of State has a website called sunbiz.com. It's very, user-friendly when it's up and working. And you can plug in a variety of different pieces of information to get information on a company, a corporation, an LLC, whatever they are, their information, their name. And you want to make sure that the name on the contract is the name of the legal entity that's going to be bound by it. Sometimes you are working with entities that are using fictitious names, which is fine. There's nothing wrong with that. It's just the contract has to show that the fictitious name or the doing business as name is owned by the real legal entity. Sometimes people forget to file all their paperwork with the state on an annual basis, and you'll be contracting with a corporation that's dissolved because they didn't file their annual report. that may be a completely innocuous issue and a clerical oversight, or it could be evidence of something more serious. So you kind of want to, run those issues down. So you want to make sure that the name of the company you're going to work with is properly reflected on that agreement and that they are an active corporation. Typically, they're going to be a Florida corporation. They could be registered out of state, and that's, can be verified as well. The other part of that I want to just touch on is a lot of times the vendor will fill in the name of the association as well.
I know where you're going with this because
As a
I was going to
courtesy,
ask
right?
that
They're
question.
helping you out.
Yeah,
And they get it wrong
right.
because a lot of association names are very similar to other condominium or communities. So you want to make sure that your name as the association is properly referenced in the agreement.
I've seen
Yeah.
that happen, Rob. So let's talk about it. Let's say there's a mistake on the contract. Either the vendor is dissolved and the association did not catch it, they did not ask you to review this contract ahead of time, and they've signed on the dotted line. So they're doing business with either the contract's in the name of a fictitious name, or it's in the name of a corporation that's no longer current. Or conversely, the association's name, they didn't catch it and it's not their name. What's the fallout from that? Let's say they get into a dispute.
Right.
How important is that mistake?
Well, it may or may not be very important. If they've got for example, if they've got the association's name wrong, but the contract has been performed or partially performed and has been ratified by the association, it's probably, courts don't like gotcha tactics. And if you got into litigation and your, entire case was,
It's
yes, my
not us.
president signed it, but they have our name wrong because we're, Del Boca Vista Section 3, not Section 4, that's probably not going to carry the day. Now, if the contractor is a dissolved corporation because for what they didn't file the annual report or whatever, Florida law says that a dissolved corporation cannot maintain an action. So that could be very significant. Although depending on the reason for the dissolution, can be fixed by filing the paperwork and paying the fee to get reinstated. So that may or may not be, a significant issue. But I think you want to take steps to just avoid all of that by doing your due diligence on the front end, making sure that the names are right, that you know who you're contracting with, that these aren't going to be issues that raise their head in the future, either by causing a problem or you find out about it because there is some other problem.
You do realize that we've been talking for 5 minutes and we're still on the first paragraph of a contract. So this is why, for people
Right.
listening, it's so important to know
Exactly.
that there is a lot to go through in these contracts. You did mention Del Boca Vista. That's just a name. I think that's the name from Seinfeld, isn't
That's
it?
the Seinfeld condo, right? I always feel like that's a safe one to use as an example.
Because it's in the public domain.
Exactly. If we say any other condo name, like someone's like, well, that's my condo. Why are you picking on me?
Well, let's talk about Jerry's father at Del Boca Vista signing that contract, but he didn't bring it to anybody else's attention on the board.
Right.
Can you talk a little bit about the authority that directors have to enter into contracts?
Sure. So this is an issue that comes up, quite often. We've dealt with this a lot, frankly, after Hurricane Ian on the West Coast, where we had a lot of damage and people signing contracts kind of quickly and without the normal protocol. So there's a concept in contract law called apparent authority. And a director, particularly an officer, so the president, the treasurer, they have the apparent authority to bind the corporation, the association, to third parties. So a contractor who, is getting a contract signed by the association president can rely on that president's apparent authority to sign that contract in their capacity as a president. That vendor is not obligated to ask for the minutes of the meeting where the board approved this contract, right? So when the president signs that contract, the vendor can rely on that unless they have actual knowledge that he doesn't have that authority. So that gets into a whole different set of issues.
So, Rob, just how dangerous is boilerplate language in a contract?
Well, they wrote it and put it in there for a reason. So, you hear clients say, well, this is all boilerplate, or they say that as if it is not important. Someone took the time to write those provisions and put them in the agreement, so they're going to mean something and have some level of importance. I think it's important when associations are negotiating these agreements, whenever I get them, what I always tell my clients is, look, the business terms are the things you cared about when you were, getting this proposal or agreement from a vendor. Those legal provisions, those boilerplate provisions are what we really care about as, your attorneys, because those boilerplate provisions usually involve things like termination, evergreen provisions, insurance requirements, indemnification, and they can include, depending on the form of the agreement, very onerous language that's detrimental to the association. So whenever particularly the other party is telling you, oh, don't worry about it, this is just boilerplate, that should set off alarm bells, because they're trying to get you to just not read, understand, and push back on certain provisions. And I find one of the values of having counsel review agreements is it's identifying the issues in the agreement. Sometimes you can't get that language changed. It's a red line for the vendor. And that may or may not be a deal breaker for the association, but now the association knows.
Are there certain vendors that they really will not change their boilerplate?
Yeah, there are some. I do a lot of telecommunications agreements, and there are some out in that market, won't name names in this setting, that their agreements are almost, take it or leave it. We're going to talk about those types of contracts later. But and I still think there's value in reviewing that type of agreement with counsel, because you kind of know where the landmines are. But some vendors, they are. Or sometimes there's provisions in their agreement that they will not agree to touch. A lot of times the indemnification language, vendors won't agree to make changes there, or like the force majeure language, limitations on liability are kind of the high points where they just say that's what our lawyers recommended. We won't negotiate off of it. And again, very rarely do I come across a provision that I tell a client, it's against my advice to sign a contract with that language.
It happens. And one option at that point is, there's a lot of competition for this work. So there's often another vendor out there that will be a little more flexible with what you see as a deal breaker.
Like, for example, one of the provisions for me is a contract that the association cannot terminate without cause on reasonable notice. Agreements that are evergreen, that renew automatically and can only be terminated for cause. I have a strong opinion that is just unacceptable. Now, sometimes, depending on the nature of the agreement, particularly like management company agreements, we may negotiate like a window of time when they first start. Like, we won't terminate for 6 months, but after that, we can terminate on 30 days notice. That's a business decision. That's not unreasonable. But provisions that say you can't get out unless there's a breach forever, or practically forever, because you have to terminate under some specific window, those are really problematic. Now, I say that there are some agreements where that's just the facts of life, like telecommunication agreements where they've installed, $5 million worth of wiring in your community. You're not going to get out of that agreement, on a 30-day termination notice for 10 years or whatever.
Well, that's a little different, though, Rob.
Different.
The investment they've made, but let's say it's a landscape contract.
Yeah.
And they're saying uncured breach.
Yeah.
Well, you get in that endless loop of you put up a notice, then they've got 15 days to either cure or commence the cure, and then they do a little bit of that, but then they're in breach of something else. It's an endless loop, I guess. And the problem is, all the while, the client is paying, the association's paying for bad service, in their opinion.
Right. Getting away from the technology contracts, and I do a lot of those, so sometimes my brain is wired for that. But in the service contracts, management, legal, although those are different, counting, landscaping, whatever. All of those contracts are providing services, but they're all really relationship. And in my opinion, you should be able to terminate any of those agreements on reasonable notice. Because like the landscaping one is a perfect example. When you lose faith in the vendor, but you can only get out through the uncured default under the exactly like you said, you're in that endless cycle. You never get out of it. The client gets angrier and angrier. The owners are yelling at the landscapers. It's just a bad situation.
You shouldn't have to trap people into doing business with
No.
you.
And it's a bad situation for the vendor. I mean, I understand why they don't, want their clients to be able to just terminate them willy-nilly, but that's just not a good situation for anybody. And in my experience, good vendors, reputable vendors will agree to reasonable termination provisions.
I agree.
Again, they may want a startup window that they don't want you to be able to fire them on 30 days notice for some window of time at the beginning. And again, I don't volunteer that, but I understand why it would make sense. But after that, the association should be able to exercise their rights to terminate an agreement because they're unhappy with the service. The example I give is like sometimes you just don't want to see that person's face again, right? The relationship's broken down.
So automatic renewal, the onerous termination provisions, those are some of the red flags. What
Yep.
about limitation of liability? And I'll give you an example, Rob. Had a contract cross my desk recently. It was for a product, and it was a relatively small amount in terms of the association purchasing this product, but it was what the product was going to be used for. The product was going to be used to relay communications for security in part. And there was a limitation of liability on the contract amount. Well, we all know that some of the biggest ticket damage awards are relate to premises liability, particularly if there's personal injury or wrongful death as a result of a breakdown in security protocols. And, I spoke to the client and said, this is just not going to make you whole, not even going to be close to making you whole. I would assume you use a keen eye when looking at limitation of liability in terms of what the potential liability might be under that contract.
Absolutely. A lot of agreements you'll see will have language that says, the vendor's liability is capped at the value of the contract, right?
Right.
Or has a bunch of exclusions for the types of damages that can be awarded, only direct damages, no, incidental or consequential damages. And for the association, it may not have a lot of direct damages because you're not a business. So you're not losing, lost profits or product or anything like that. So that's an important provision. One, to try to negotiate better protections for the association. And two, going back to what we were talking about earlier, depending on what the vendor is willing to do, understanding the risks that are inherent to the agreement based on those limitations. Maybe depending on the nature of the agreement, there's a conversation you need to have with your insurance professionals to see what kind of insurance coverage you could have if claims were brought due to that vendor's actions that expose the association to liability so that there may be further protections just beyond what the contract would provide for. The limitation of liability section in most contracts, you'll see them. They're usually in all caps and bold because they're highlighting that. They're seeking to, limit their liability through the agreement. They're going to be enforceable if those provisions are in the agreement. And that's another provision that some vendors may or may not have an appetite to negotiate. So I think depending on the nature of it, if it's limiting it to, just the value of the contract, depending on the type of service or product you're purchasing, that may be very insufficient to protect the association. The other thing that is a reality is depending on the nature of the damages that are incurred, that vendor may or may not have the ability to pay those damages regardless of what the contract says. So that's always something to be aware of, particularly if you're working with a very small company or a new company. Again, not a reason to necessarily not contract with someone, but it's a reason to understand what's in your agreement.
You could pay $7,000 for an engineering contract to have a report and then be subject to a damage award of millions of dollars if that report was somehow flawed. So
Yep.
you're right. There has to be some tie-in between the service you're contracting for and the potential risk associated with that service. I will tell you, despite the disclaimer in the bold language, Rob, I think most lay people gloss right over that limitation of liability language.
It's funny you say that. I think when you put stuff in a contract in bold and caps, it almost encourages people to skip it. It's a weird psychological effect. I think your brain just says, well, that's just not
standard. That's standard.
It's back to boilerplate. You can't change it. You just kind of gloss over it.
So I've asked you what you don't like. What do you insist on in almost every one of your contracts? I'm going to start off with saying one I do. I like a mutual, reasonable, fault-based indemnification clause. Okay? And I'm going to say that again. Mutual, reasonable, fault-based. Usually we find onerous, unilateral, and almost ridiculous indemnification provisions.
Yep.
What about you?
I 100% agree with that. It's interesting because when you see those one-sided indemnification provisions, so the association's indemnifying the vendor for everything under the sun, and if you're lucky, maybe not for gross negligence, which makes no sense because they're the ones doing stuff, right? Under most agreements, the vendor's doing things and the associations are writing a check. Why would the association indemnify the party that's doing things?
Well, that has the knowledge,
right?
That has the skills, and you're absolutely right. But again, we started out saying these contracts are created by their attorneys to protect those vendors.
Yeah. But to your point, well-drafted indemnification provisions, like in a perfect world, the association has no indemnification obligation and the vendor has to indemnify us. But that's just not realistic. So when you have that mutual provision excludes negligence, so you don't get indemnified for your own negligence. You're being indemnified when a claim is brought against you and you are not negligent. So that means you're kind of an innocent party. So that makes sense. I really push for, we touched on it already, termination without cause on reasonable notice. I push for appropriate insurance provisions where we get insurance certificates. We're named an additional insured. It has specific insurance limits, minimums in the agreement that they are obligated to maintain. And if they don't, that's a breach. That protects the association and gives you certainty that this party, one, if you have reasonable but significant insurance policy obligations, it gives you some validity that, okay, this company we're contracting with is, a real ongoing concern that has, appropriately purchased insurance policies. Not a guarantee of anything, but at least it gives you some additional level of comfort. The other thing red flags that just really push against are evergreen provisions. This agreement, renews automatically. And you see these in landscaping agreements for some reason. It's like they have initial 3-year terms and they renew automatically for 3-year terms. And there's automatic price escalation built in. I mean, it's wild.
You know what, Rob, before you step off that topic, some clients like these automatic renewals because they think, well, you know what, we won't have to go back and we won't have to negotiate on them. But I think there's more risk involved with them, particularly when they tie the termination and they limit your ability to terminate on the 90 days before the end of the first renewal period. It gets very complicated.
Oh yeah, it's an automatic renewal where you can't terminate without cause, and you can only terminate it no more than 90 days, but no less than 45 days before the renewal term. It's like a word problem to figure out when you have to deliver notice. So, an evergreen provision where you can't terminate without cause is a recipe to get locked into a bad arrangement. If there's automatic renewal, but you can terminate at any time on reasonable notice, I have less concern because you can still get out of it even if it renews. Although I do have practical concerns with automatic renewal because I think it allows boards to kind of fall asleep at the switch and the contract automatically renews and the price automatically goes up, and you're not going back out to the marketplace to see if there's better options out there. Now, maybe, you put it out to bid and you still go with the same vendor, but you negotiate better pricing or better service or whatever. So I think it encourages laziness on both parties' part, but particularly on the vendor's part. If you're not pushing them to get the most out of your agreement, there could be some inefficiencies there.
Let's talk about lengthy terms, because you do review a lot of telecom and tech contracts. Now, I realize they have to make their money back if they're investing and they're laying cable and fiber and all the rest of it, but 10 years, 15 years on some of these contracts? What do you think?
They give me pause, to be blunt, particularly telecommunication agreements that are bulk agreements where the association is purchasing both bulk video and internet. The question on whether or not bulk video as an ongoing desirable product for most associations, I think is an open question. It's an open question today, and I think it gets more and more questionable as we look to the future. Now, I will say this. With a lot of the providers I work with, or our associations work with, and I review their agreements, they are putting in technology reviews at certain points, 3 years into the agreement, 5 years into the agreement, or annually after 3 years, to where the association can drop the video for a preset percentage discount on the price, thinking that, maybe the bulk video, the cable model, is not really desirable at that point in time. I will speak, for example, in the community I live in. We just went with a bulk provider, but only bulk internet. They did not purchase bulk video, even though the provider we went with sells bulk video if you want it, with the idea that people don't want the bulk video service. Now, it's going to be very much community specific. I'll use my example again, single family home community, varying age groups, people are relatively tech savvy. So they could say, well, I went with YouTube TV, or I, bought the video from the provider, or I kept Comcast or whatever, versus, maybe condo buildings, more seasonal residents, maybe rentals. They say, well, we want the bulk video package because that's what the people who occupy our units expect, or it's convenient. So it's a varying situation. Bulk video, though, I think does have an expiration date on it. I just don't know if we know if it's in the next 3 years, 5 years, 10 years. But back to your original point, those long agreements, are significant because the association is, buying into that for that period of time. The problem, though, particularly with a new provider installing their network, they're not going to price it competitively without that, period of time to make their money back. That being said, I see a lot of providers who are not putting in new systems still wanting 10-year agreements. And that may be an opportunity to push back and say, well, we've already gone through the build out. You've already gone through the initial buyback period for your system. Why do you need, a second 10-year deal? So sometimes those second deals, for example, you may be able to get a shorter period of time.
So let me give you an example of another type of contract that typically has lengthy term, and that's these elevator maintenance contracts, which often, I should say almost always, contain a right of first refusal. So the elevator company gets in, they are maintaining the elevators, but they tuck in that little clause that if you're going to modernize the elevators, where there is also a lot of money to be made because they're overhauling it, both the functionality and the aesthetics, they get to exercise a right of first refusal. Do you try to yank those right of first refusals out?
Always, in every type of contract, because that's not what we're, negotiating for, right? It's for this service today, not some future service. And those right of first refusals, I'm seeing them in more and more types of agreements, including telecom agreements. But elevator contracts are, maybe, not to make a bunch of industries angry. The only contracts I can think of that are worse than elevator contracts are laundry contracts for some reason.
Yeah.
They're a whole different animal unto themselves. So, elevator contracts are really very onerous. I find that very hard to negotiate changes to. And that modernization issue raises issues because depending on what your service agreement says, you may not be contracting for the modernization, but if the modernization overlaps with the service agreement, you may have a problem with them servicing in a elevator they didn't modernize, right? So I think you have a bunch of issues there to be very careful with. And I'll say this, I have partners in our Fort Myers office on the West Coast that handle elevator issues as part of their construction practice. So whenever I get an elevator contract, I give it to someone else.
Well, I mean, this is also where I think the transitions on boards, Rob, plays a factor because this board today may only be looking at that contract with their current need, which is we need to maintain these elevators. And they're
Right,
not thinking that they're locking the association into a right of first refusal for a modernization project that's 7 or 8 years down the
right.
road. And so this is why it is important, once again, hope we're driving home this point, that there be not only discussion with your lawyer about all of these terms, but also amongst yourselves about what's on the horizon for the association.
No, absolutely. I think this raises issues of internal governance questions, of good governance, of good record keeping, of understanding what all contracts you're a party to as an association, what are the expiration dates on those contracts, or the renewal dates, or termination options. And for a big condominium building or a master plan community, you could have dozens of contracts of varying sorts, and keeping up with those, is a significant undertaking that, I think associations really need to think about how are you both maintaining those agreements but monitoring them.
You're right, Rob, that we're seeing provisions in certain types of contracts that we never saw before, like that right of first refusal, okay? Never saw that in a telecom contract usually, but now it's in there. You know what else I'm seeing? These non-solicitation non-competes in like a landscaping contract or a
Right.
pool contract. Have they all gotten together and just started working off of a boilerplate or
Yeah.
talk to me a little bit about those type of provisions regarding non-solicitation. Certainly for management companies, this is where these provisions first started, and it does make sense in the
Yeah.
management context. But for these other vendors, I'm a little confused.
Yeah, I am too. And there was pushback at the federal level. There was a rule adopted by the FTC, I believe in 2023, outlawing non-compete agreements in employment contracts. Doesn't really go to what we're talking about, but it ties together. That rule, while it is on the books, it was adopted and finalized, is on hold pending litigation in the federal court. So it doesn't apply today or is not effective today. I think it's just another protectionist act by vendors. I was actually reviewing an agreement for golf course management agreement that includes, the superintendent and the groundskeeper and all of that. And they had a similar provision. And there's a limited number of people that do that. And those people changed companies, and there was a question on could they hire this new company or not. They worked around it. But when you're talking about a pool technician or a landscaper, it doesn't make much sense that those people's skills are, while they're skilled, they're
Right.
not the type of skills we need to protect companies from those people moving from one company to another. So I would push, those are the types of provisions you would work on pushing back on, trying to remove or limit, um, if possible. And if not, it's something that you just need to be aware of and put on your radar. The issue though is how do they get enforced? Because you may not know who your landscaper employs.
Well, it's funny you say that because I typically say if I can't get it out, I insert the word knowingly. Because
Mhm.
just to your point, how do they know if your
Yeah,
new company has employed somebody from the old company?
right. And those are also the types of provisions you only see enforced often, let me say, see enforced when there's some company has broken up, there's bad blood, someone's mad at somebody and they're looking to,
Draw a little blood?
Yeah, exactly. So you want to get out of that as best you can. Now, with the management company agreements, to your point, I always try to take everything I try out, but that's not an unreasonable provision. The management industry is a relationship business. It is a labor intensive business, and hiring, training, licensing managers is a significant undertaking. I understand that. So the idea that you don't want if you're a management company, you don't want your association client terminate your agreement, then hire your manager in-house because that is a bad business model. I mean, again, I don't represent management companies, but I understand the issue. So what you see oftentimes in those provisions is it says you can't do that, but if you do, we're going to agree up front on what the buyout
On what it's going to cost. But it is important to distinguish management agreements from these other type of agreements we're talking about, because the management company, they're the manager you've employed, they're your agent. So that's an
Right,
agency relationship. I understand the need to indemnify your agent. Think about that. But these
yeah,
other affiliated companies, even if they're a management company affiliated pool or landscaping, or
right,
they're third party vendors, that's different. As you
totally
said
different.
before, they've got the knowledge, they've got the skills, they're performing the service, and you're relying upon them. They're not taking direction from you the way
Right.
your management company is as your agent. I did want to circle back because I made a little note about the indemnification. More and more people are getting a little clever and putting in that the vendor, and let's even say the management company, they'll indemnify you if they are adjudged solely liable for X,
Right,
Y, or Z. That's a really high standard. Adjudged means you've gone to court and
right.
a judge has decided on it, or a jury. Solely means solely. So in
Yeah.
a premises liability context, you could potentially have a vendor or management company found responsible for 99% of the issue. That's not 100%.
Yep. I have seen them not on the West Coast. They have not made their way into the management company contracts I've been reviewing that I recall. But I have seen that solely adjudged language in other agreements and have sought to push back on it. The problem there too, not just with the 100%, 99 and 1% liability, is very few cases go to judgment. Most cases, vast majority of cases, settle at some point in the proceedings, and that raises issues unless the parties come to an agreement on whether or not that indemnification provision is or isn't triggered. But with management company agreements, kind of to identify and illustrate the differences, often we will discuss in management company agreements about the manager, particularly for on-site management, that the manager is, insured by our policies as well, that they're a named insured, that they're on our fidelity bond, in addition to whatever policies they carry, so that there is insurance coverage on both sides that hopefully resolves a lot of those types of issues.
What type of contracts do you insist on including an incidental or consequential damage clause?
Well, anytime that a vendor is going to do work or construction work on the property, you want to ensure that it's clear that they're going to be liable for damage that they cause, not just directly, but also if there's, indirect damage due to, they break something and then that cascades and causes other problems. You want to ensure that that is addressed. Now, a lot of agreements are going to seek to limit consequential damages and just say that we're only responsible for direct damages. And that's going to really become a business decision for the board depending on the nature of the agreement. So it varies. It really, in my mind, turns on what is the vendor doing. What
Right.
type of work are they doing on the property? The problem is the more likely that there are to be significant consequential damages, everyone knows that at the outset, so the more likely the vendor is going to have bad language in their agreement on that issue, right? So it's kind of a tension, and it goes back to, one of those issues of trying to negotiate up front. And if you can't make changes, understanding, what the limitations of the agreement are. Going back to, your example about security contracts, having high risk, because that's where some of these big judgments come from when there's a breakdown in access control or whatever. Those are also some of the security agreements with some of the worst damages language, because they know that their conduct can lead to, extraordinary consequential damages depending on what happens. So there's another area where there's a tension between the parties, because the association is going to want an aggressive consequential damages provision in an agreement they know creates risk, whereas the vendor also knows that and wants the exact opposite.
It's so important to frame this discussion about contracts in terms of what is the party doing with whom you're contracting.
Yep.
I'll give you an example. I had a client years ago, Rob, and they were just, it was a homeowners association, small homeowners association. They had paid a company come out and clean their French drains in their roads. And it was a small contract. I remember the president telling me, she said, listen, Donna, it was only a $2,500 contract. We didn't think we should have sent it to you. But instead, the company used the wrong method. I don't know if they were supposed to use a dry method or a wet method, but they used the reverse of what they were supposed to do. Long story short, it ultimately resulted in about $100,000 in damage.
Oh, wow.
So the question is, when clients say to you, Rob, look, we're a small community, you've got small communities like I do as well. Do we really have to send you every contract, Rob? I mean, what if it's only, a $2,500 contract to buy patio furniture? That's a little different than a service agreement. But what do you say to clients who are trying to figure out from you how to budget for contract review?
Right. No, I think that's a great point. It really boils down to not just the value of the agreement, but what are they doing? And I think anytime a vendor is coming on site and doing work to the physical plant of the condominium, the association or homeowner association, I always have condominium brain, but you really have to take a step back and say, we really need to review our exposure, because they're going to be on site doing something. As opposed to your example, they're delivering, you're buying furniture. I mean, that's kind of a discrete, self-contained issue, So I think the value of the agreement is a material question in whether or not you want to engage counsel to review a contract and revise a contract, because, you don't want to spend more on legal fees than you do in the substance of the agreement. I get that. There's practicality to it. But I think the association should up front understand that contract well enough and what they're asking that vendor to do to gauge their risk, at least in a very general matter. So they can then say, this is something we need to consult counsel with. But it's kind of one of those things, hindsight's always 20/20. If you have a problem, you're going to wish you had it reviewed. But I think issues like, how much is the contract? Is someone coming onto your property to do work to something? Is the thing they're working on something that can damage something else? I have clients that have sprinklers in their units. One of the sprinklers is located in the closet where the air handler is. And anytime a air conditioning company has to replace an air handler, they have to turn the water off to the sprinkler system. Because if you use I guess they have to weld something. If they do the welding in there without doing that, it sets the sprinkler off and it floods the building. So, replacing an air handler costs $2,700. Repairing the flood from the air handler when they set the sprinkler off, the last time they did it was $300,000. So, that $2,700 contract needs to be reviewed, versus the guy replacing the sprinkler heads, on your irrigation system, maybe not. So I think some of this, the association needs to kind of internalize, what is this work and what are the worst case scenario, and then kind of make a decision. Also, I've had homeowner association communities in particular, where we've worked with them on kind of form addendums to certain types of agreements. So maybe they don't have to come to this every time, but if it's a relatively small agreement, a lot of landscaping type stuff, where they just try to add this addendum to the agreement that has a couple of material terms they find it important. One size doesn't necessarily always fit all, but it gives them some level of comfort. I think if the agreement is discrete, a one-off, set price, set scope, maybe it doesn't require significant legal intervention versus agreements that are ongoing, that are going to renew over time. That's a whole different animal. So I think that's another question the association, really should ask itself. What is the time investment of this agreement? Is it the guys coming out on Saturday to pressure wash the driveways, or is this something that's going to, go on for a year or more?
Before we wrap up, let's talk about the very worst contracts, because we've been talking about pretty standard contracts. I mean, boilerplate is to be expected, but let's talk about contracts that may be illusory, and also a contract of adhesion. And I'm going to give an example for our listeners. If you've ever clicked "I agree" on like the Facebook updates or any of your social media.
Apple's terms and conditions.
Apple's terms and conditions, no edits, no negotiation, just blind trust and fingers crossed.
Right.
I think you've just signed an adhesion contract, but can you just spend a minute or two, Rob, talking about the worst kind of contracts?
So an illusory contract, kind of going back to the very beginning of the discussion, when we're talking about proposals versus agreements and contracts, an illusory contract is a contract that's unenforceable because it is so vague or non-specific as to the material terms that, it can't be enforced. So a contract that has no price or a contract that has no term, things like that. If you're not able to determine from the face of the agreement, what you're buying for what price over what period of time, something like that. So we often see that where there's no scope of work, no pricing, things like that. So that's going to be illusory. There's no enforceable agreement. So again, I think it goes back to, work out the business terms of your contracts with the vendor and then work with your legal counsel to finalize the agreement, whether it's negotiating off of the vendor's form or having your attorney drafted or whatever, and you'll avoid those illusory problems. Now, contracts of adhesions are a whole different animal. That concept, the black letter law definition is it's a contract of unequal negotiating power. You have one party that is so strong in the negotiation that they can just tell you to take it or leave it. The classic example, in addition to like the software companies' terms and conditions, are insurance contracts, for example.
I was just going to say insurance, take it or leave it.
That's like the classic example are insurance policies or contracts of adhesion. It's not that they're not enforceable. They absolutely are enforceable, but you can't negotiate the terms. Typically, this is what they're willing to provide you. What I tell clients with any contract, outside of kind of the worst case examples we talked about, is ultimately this becomes a business decision. If you get a vendor that says, and I've seen non-negotiable contracts in other instances. I've had a few examples where there's, maybe one vendor who does a certain thing and they know that. And they say, like, we got enough work and we're not going to, like, this is the deal. Sign it, take it or leave it. And then the board has to make a business decision. Again, contracts of adhesion, unless there's other evidences of fraud or unconscionable conduct or incapacity or whatever, they're enforceable. Just because your insurance company or some other vendor is unwilling to change their contract doesn't mean it's not enforceable against you if you sign it and agree to it. Depending on the nature of the service you're seeking, a contract of adhesion may or may not, be expected or appropriate. But again, it kind of boils down to a business decision.
Try to avoid them. And when it comes to insurance policies, contact your public policy maker. Because that's probably your best bet, to go to your state rep or state senator and say, what are you all doing about these insurance policies?
Yeah, those issues are probably only resolved in Tallahassee, unfortunately.
I think so, and in other state capitals as well. Rob, you have been so generous with your time. You're helping our listeners, I'm sure, save headaches down the road, because miserable contracts can really impact quality of life in these communities for many, many years. Yep. Any final thoughts?
If you're going to talk to your lawyer, talk to them before you sign the contract. We joked about that earlier, but it's a joke because it's true. I've had that happen. The other thing is, don't feel pressure to sign an agreement you're not comfortable with. regardless of the circumstances. I'm located on the west coast of Florida. We've had serious, hurricane situations from Charlie to Irma to Ian and Milton and Helene. Community associations have had damage, but even in the response to an emergency, there's time to take a step back, understand what you're signing, not agree to contracts you're uncomfortable with. I think that is the two things I would take away for our association audience members is, even under the worst circumstances, you can take 24 hours to try to figure it out.
It's great advice, Rob. Thank you so much for joining us today.
Thank you.
Thank you for joining us today. Don't forget to follow and rate us on your favorite podcast platform or visit takeittotheboard.com for more ways to connect.